Good afternoon. My name is David Johnson. I'm the Executive Director for the Center for Ethics and the Rule of Law, CERL. Thank you for joining us for the fifth in our virtual briefing series on the legal dimensions of the Israel-Hamas war. The ongoing conflict between Israel and Hamas raises critical questions about the application and interpretation of the law of armed conflict, LOAC, otherwise known as International Legal Principles Governing Conduct of War. Searle is pleased to host experts in national security, military strategy, and the law of war to discuss these critical topics. Searle is a nonpartisan interdisciplinary institute dedicated to preserving and promoting ethics and the rule of law in national security, warfare, and democratic governance. Affiliated with the Annenberg Public Policy Center at the University of Pennsylvania, Searle draws on the study of law, philosophy, and ethics to answer the difficult questions that arise in times of war and contemporary transnational conflicts. Searle brings together scholars, policymakers, professionals across legal, military, intelligence, and the business sectors to research, analyze, and make policy recommendations that address today's challenging issues such as domestic violent extremism, the use of autonomous weapons, and the protection of civilians in war zones. Searle carries out its mission through conferences, symposia, research, policy papers, briefings, blog publishings, and student projects, and other activities. Please take note of a few housekeeping items before the session begins. Questions will be taken from the audience in the last 20 minutes or so. To ask a question, please enter your question in the Q&A box at any point during the conversation, then click send. This event will be recorded and posted on Searle's YouTube channel in short order. All right, now I am pleased to introduce the moderator, Professor Claire Finkelstein, who founded Searle in 2020 and has served as the faculty director of it since its inception. She's the Algernon Biddle Professor of Law and Philosophy at the University of Pennsylvania Law School. Claire?
Thank you so much, Dave. And thank you all for joining us. We have not met since before winter break, so there's quite a lot to catch up on. Before I introduce our guests for today, I'll run down some of the major items that have happened since our last briefing, though we're only going to be focusing on one today. So first of all, combat continues in Gaza, and peace talks have apparently not resumed or not resumed with any effectiveness. There was hopes and discussions for a new deal that would start releasing hostages again, but those have been entirely deadlocked. With the parties, from what we know, from what we can tell, nowhere near being able to reach agreement. The Houthi rebels have continued their siege in the Red Sea, and British and American forces have struck there, so it looks as though there is a combat situation around Red Sea passage. Just yesterday, the UN Security Council demanded an immediate halt to attacks by the Yemen Houthi rebels. And so there is international focus and a sense of international urgency. Meanwhile, in Gaza, in the last several weeks, there were several deadly strikes in central Gaza. Casualty rates were also extremely high, highest since the war began in the last several days in Gaza. Israel has acknowledged potential fault with respect to strikes right around December 24th, with respect to two strikes in particular, where there were high casualty rates, and those will be investigated. And meanwhile, pressure has increased from the U.S. administration for Israel to pull back on its offensive. Some troops have been cycled out, and it looks as though there may be a slow transition to a more limited, more targeted operation, which the U.S. is stressing they are in favor of. So today, the topic that we're going to focus on is South Africa's filing and complaint in the international court that has been taking place today. South Africa presented its case, and tomorrow there will be the defense by Israel. For those of you who didn't have a chance to hear it, because the hearing started at 4 a.m. in US time, 10 a.m. at The Hague, there were extensive presentations made with an attempt on the part of South Africa to make a case that Israel is committing genocide in Gaza. It should be stressed that this is a preliminary hearing. It's a hearing to establish jurisdiction, and the ICJ will have to decide whether or not it takes jurisdiction of the case. And we'll be talking about the criteria for its doing so. Today was also an application for what is called provisional measures. Namely, that South Africa is asking the court to require Israel to halt its military operations in Gaza, and it has a number of other requests. The full determination of whether or not, in fact, Israel is committing genocide in Gaza will take many, many years. That's not something that the court will decide anytime soon. So the issue at hand is whether or not there will be provisional measures required by the ICJ of Israel as it submits to the jurisdiction of the court, which it apparently has done willingly in this case as a signatory to the Genocide Convention. So let me introduce our guests today who will discuss this process with us. I'm delighted to introduce Jens Ohlin, who is the Alan Tesler Dean and Professor of Law at Cornell Law School. His work focuses on 4 interrelated fields: criminal law, criminal procedure, public international law, and the laws of war. His background is both as a lawyer and a philosopher, and he has focused on many issues in the law of armed conflict. His latest research involves foreign election interference and the use of disinformation by foreign actors. I should also say proudly that he is the co-editor with me of the Oxford series in Ethics, National Security, and the Rule of Law, and he is a board member of the Center for Ethics and the Rule of Law. So thank you, Jens, for joining us. I am also proud to introduce Professor Amichai Cohen, who is a member of the Faculty of Law at Ono Academic College, and he is the head of the Amnon Lipkin Shahak Program on National Security and the Law and Senior Fellow of the Israel Democracy Institute. He has served as the Dean of the Faculty of Law at the Ono Academic College and as a visiting professor at American University Washington College of Law and at Columbia Law School. He was also a visiting scholar at Cambridge University and at the Swiss Institute of Comparative Law in Lausanne. He is the author of many books relating to national security, including Israel's national security law, revolutions and counter-revolutions, and proportionality in international humanitarian law. So thank you so much to both of you for joining today to talk about the ICJ process. Jens, could you start us off and explain, first of all, what is this court? Because I think a lot of people do not know and do not understand the nature of the court. What is its jurisdiction based on, and what is this process today?
Absolutely, I can totally do that. And thanks for having me. I really appreciate it. It's an important topic. So the International Court of Justice, sometimes nicknamed the World Court, was established as part of the United Nations system after World War II. It sits in The Hague. There are judges from many different countries sitting at the ICJ. They don't formally represent the countries that they come from, the judges. They're independent judges. And the court is really a forum where one state can file a case against another state for a finding of state responsibility. So the parties to an ICJ case are always nation states, not non-state actors, and also not individuals. That's what really distinguishes the ICJ from the International Criminal Court, also in The Hague, which can prosecute individuals and punish them, and they can go to jail. So this is not a criminal court. It's just a case. I mean, it's just a tribunal that can hear disputes between states. In terms of how the court acquires jurisdiction, very quickly, there's usually three tracks by which the court can find jurisdiction. One is a kind of plenary jurisdiction. If a state has joined the court as a full member, what that allows them to do is to file cases against other member states, and in return, they then accept the jurisdiction of the court for any member state that wants to sue them for any violation of international law. The second track is if a particular treaty includes a jurisdictional grant to the court, and a state is a member of that treaty, then that gives the court jurisdiction over that state. That's particularly relevant here because the Genocide Convention has one of those clauses which says that disputes arising under the Genocide Convention can be heard by the International Court of Justice. The third avenue by which the court can exert jurisdiction is if two states decide that they voluntarily want to submit a dispute that otherwise the court doesn't have jurisdiction over. They can both voluntarily say, hey, we're locked in this international dispute. We would like the World Court to resolve it for us. That's a little bit less relevant in this case.
Right. And just one last thing before we delve into some of the substance of today's arguments, which is how are the judges chosen? There's an enormous number of judges, and I gather that some of them are permanent judges and some of them are ad hoc judges, and that in this case, both countries had the opportunity to choose ad hoc judges to sit on the panel. How are the rest of the judges chosen?
Yeah, so you're absolutely right that South Africa gets one ad hoc judge and Israel gets one ad hoc judge because they're parties to this particular case, and then the rest of them are the regular judges, and they are chosen through an election process. There's kind of an arrangement in the UN system about having the major powers represented, but then other countries get to submit nominations for judges, and then there's an election, and the countries themselves vote on members. And for example, an American professor, Sarah Cleveland, was recently elected to the ICJ through that election process.
Right. So we're going to talk a little bit about the implications of any decisions regarding provisional measures. But Amichai, if we can go to you and talk about the substance of the case. South Africa submitted a complaint, long, over 80-page complaint, and then they make their oral argument. So far, Israel has not, is my understanding, has not submitted any written defense, though Israel will have its day in court tomorrow to present a defense. But what is the tenor of South Africa's complaint based on, and how do you think the prosecutors, or rather complainants, presented this morning?
So thanks for having me, and good afternoon to you. It's good evening in Israel. And as Dean Ohlin said, the jurisdiction of the court here is based on the Genocide Convention, the Convention for the Prevention of the Crime of Genocide. and hence the jurisdiction of the court is limited only to discussing the crime of genocide. So South Africa, in order to be within the jurisdiction of the court, South Africa has to prove, or at least at this stage, pose a plausible claim that Israel has committed genocide. And in understanding the crime of genocide, it has two legs. One is the factual one, so severe violations of international law, killing or harming, creating bodily or mental harm, or creating conditions of life that would not allow survival. So that's one part of the crime of genocide. And the second one is the intent. Intent is actually what differentiates the crime of genocide from other international crimes and turns it into the crime of crimes of international law. And it's the intent to destroy in full or in part, and in part, several courts have said in significant part, an ethnic, racial, national, or religious group. So you have to show a plan, an intention to destroy in order to give these acts, these factual acts, which are violations by themselves, to turn them into the crime of genocide. And what South Africa tried to do today is present both, of course, both sides. So I would say in analyzing what happened today in court, I would say two things. First of all, needless to say, war is terrible. And the situation in the Gaza Strip is terrible. It's an area in which 2 million people, many of them civilians, are in war, in a war zone. But listening to the claims from South Africa, and if I had no idea about the situation on the ground, I would have thought that Hamas is already gone from the area. So there was no explanation of why Israel is actually attacking and destroying, and all this suffering, where it comes from. And of course, the fact that a lot of people have been evacuated from Gaza City at the beginning of the ground operation was not explained. There was no explanation as to why Israel did it, and the idea that Israeli soldiers are being killed every day by Hamas terrorists, that the kidnapped persons, more than half of them, are still in the Gaza Strip. All this did not appear at all. So the factual ground, as I said, they presented a terrible situation, and indeed the situation. I don't think there is anyone arguing with the fact that the situation is terrible, but the question of who's responsible and Hamas's responsibility was completely ignored. And now to the second, and I would say more important part of proving genocide, because the fact that there are, even if there are violations of international law by Israel, this is not sufficient. It's not sufficient because the court doesn't have jurisdiction over violations of the laws of armed conflict. It only has jurisdiction if South Africa is able to prove the intent, which is what differentiates between regular, quote unquote, violations of international law and the crimes.
Let me pause you there
genocide.
for 1 second, because this is a very tricky point that I want to focus on. The decision of the court as to whether or not Israel is committing genocide won't come for many, many years. That's something that will be at the end of a long process. However, the decision whether or not to issue provisional measures, and to say, for example, one possible provisional measure would be to say there must be a ceasefire. You must stop. You must stop your attacks in Gaza. Depends on having jurisdiction through the Genocide Convention. So how do they know whether or not they have jurisdiction until they figure out if Israel is committing genocide?
So in fact, they have to show South Africa has a relatively low threshold for us. It's the plausible threshold. The claim is not frivolous. It's a plausible claim. And the fact that there are perhaps violations of international law, as I said, is not enough. But in order to intention is quite tricky to prove. So what the South Africans did is they, I think it's cherry picking. They cherry pick utterances and tweets and claims made by politicians. Some of them insignificant, some of them outside the decision making, the actual decision making circle. And I want to say upfront, these things that some Israeli politicians have said, for example, that the Gaza city has to be leveled and that there are no uninvolved civilians. These should be condemned. I have no sympathy to these things said. But then what South Africa did is they completely ignored the entire gamut of declarations from the Prime Minister to the Minister of Defense to the Chief of Staff to an extensive record of declarations that Israeli officials have said, we are fighting only Hamas. We have no fight with the Palestinian people, and we are trying at least to do it according to the international law. They completely ignored all this, and they showed it's a disturbing picture. And once again, I have no sympathy to these statements, but they, I think, to my mind, but then one could say I'm biased, but I think I'm speaking from the Israeli perspective. I don't think it's a convincing claim that there is a plan in Israel to destroy the Palestinians. I would even say the following. Israel has done things that raised a lot of criticism in the international law community over the past 3 months. For example, the way the evacuation of Gaza City was conducted. And perhaps, and I don't think we're ready to come to conclusions now, perhaps there were violations. I don't know of any armed conflict in the history of the human race in which there were no violations of international law. And so I accept that there were also perhaps violations here. But the discussion has to be, why has the evacuation taken place? The fundamental question is, why should Israel go to the trouble of this evacuation of people if the plan is to destroy? Why should Israel risk the lives of the Israeli soldiers if the plan is actually to destroy the Palestinian people?
So let's break down these different elements piece by piece. And Jens, let me first circle back to the jurisdictional question that I asked, which is, if the ability, because I really want to get clear about this, if the ability of the court to issue provisional measures is dependent on Israel's committing genocide under the 1949 Genocide Convention, then why doesn't the court have to figure out whether or not, in fact, Israel is committing genocide first before such measures would be legitimate?
Okay, so let me break that down, because those are that's a great question. It's composed of multiple, I think, sub issues. So first, this is a structural problem for any court whenever they have to determine that they have jurisdiction, if their jurisdiction is granted under some particular, subject matter jurisdiction that's very narrow, as opposed to just a kind of plenary jurisdiction that a court has. So you often get a situation where a court seems to have to delve into the merits in order to satisfy itself that it has jurisdiction. And like Professor Cohen said, they basically have to run through the analysis at least twice, if not more, first at the jurisdictional phase, and then they have to redo it at the merits stage. That's a little bit weird, as you kind of point out, and it's a little bit incoherent, but it's kind of baked into the problem of jurisdictional requirements. And as Professor Cohen, I think, was correct, what is different between doing it the first time for the jurisdictional phase and then the second time for the merits stage is that the standard that you use to judge the question changes. So at first, you only have a very low threshold in terms of how convincing your case has to be to establish jurisdiction. The other thing that I'd say is that the Genocide Convention is a little bit quirky in terms of the jurisdictional grant. It doesn't actually say that the ICJ has jurisdiction when a state has committed genocide. I mean, it can be read that way, but that's not the actual language that the Genocide Convention uses. The Genocide Convention says disputes arising under this convention can be heard and resolved by the ICJ. Now, this is relevant because in the dispute between Russia and Ukraine, which is a separate armed conflict, but also has come before the court under this same jurisdictional clause in the Genocide Convention, Ukraine made a very interesting argument where they said, we're not, we haven't, they didn't assert that Russia was committing a genocide against Ukraine, although I think actually there's an argument that they have. But Ukraine said, we're not accusing Russia of committing a genocide against us. We are actually complaining because we've been falsely accused of genocide. Therefore, there is a dispute between our two countries over the facts and law related to whether a genocide has occurred. And the court, I think, basically accepted that argument in Russia versus Ukraine. And so if you take that kind of legal framework, I think it does match what's going on between South Africa and Israel. They have a dispute. One side says that a genocide is occurring, by Israel, and Israel is obviously saying no. So in that sense, there is a dispute between the two parties, and that's probably enough. The other thing, I'll mention about the jurisdiction, a lot of people wonder, well, why is South Africa filing this case in the first place, given the fact that they're not being involved militarily in this conflict? Other than the fact that they have some political alliance with the Palestinian cause going back, at least 25 years, they're not an interested party. So why do they even have standing to sort of pursue this case? And how can the court accept jurisdiction? That's kind of a recent development in the jurisdiction of the ICJ over the last 10 years or so, but they've moved in this direction of recognizing that the obligation not to engage in genocide is not a bilateral obligation between two states. It's an obligation that runs between all state parties to the Genocide Convention, and arguably between all states, in the world, because this is probably a mandatory norm, which is even more
what we call use Kogans.
Exactly. And so, this theory, which I think was relatively novel about 10 years ago, has really sort of taken hold. And so the idea, I think, that we're getting to is going to be a system where any country, as long as they're a signatory to the Genocide Convention, can accuse any other state of genocide, and then the case will have to go before the court, and there'll probably be jurisdiction will be found, and then you'll go to provisional measures.
Well, and that's exactly the problem, because if there's such a low threshold for granting jurisdiction, then the Genocide Convention becomes a bit of an excuse for getting an audience, getting into court, and getting the ICJ to hear your case, where the ICJ does not have jurisdiction over ordinary war crimes or claims that Israel's offensive is disproportionate. And so by claiming genocide, they are enabling the court to hear certain claims about possible violations of war that it wouldn't normally have jurisdiction over.
Yeah, and one thing before, I know that Professor Cohen wants to get into this too, the risk associated with this expansive theory of jurisdiction is that if really you get a plethora of cases coming before the ICJ using this kind of scheme, some states, more states, might say, we're withdrawing from the Genocide Convention because we don't
exactly.
want to be subject to the ICJ jurisdiction, and having a run to the exits from the Genocide Convention would not be a good thing for international law. That would be very bad. So that's the risk. Sorry.
Amichai.
Just 2 points. First, the Genocide Convention's original intent was to create individual responsibility, not to create state responsibility. It's a recent development, and Dean Ohlin, of course, was correct, but it's also a recent, relatively less recent, so 2 decades, development that state responsibility is discussed in the context of the Genocide Convention. If you read the Genocide Convention, the duty of the state is regarding punishing, suppressing, preventing the commission of genocide by individuals. And the second, regarding the question you just raised regarding the trade-off here, right? Opening up the court. And what the court has done is, although it allowed states to enter the court with claims of genocide, it set a very high threshold for proving genocide. So there's actually only one case in which the International Court of Justice has said that there was a genocide. And this is actually not a decision of the International Court of Justice. It was a decision of the ICTY, regarding the Srebrenica crimes of the Bosnians war. In all other cases, we do not have a case in which the International Court of Justice has actually said there was a genocide here and the very high threshold was passed, which raises the question and the importance, I think, apart from the fact, and I think, and Dean Ohlin correctly said, states would exit of the importance of the provisional measures. Because if it's very complicated to prove at the end of the day that genocide was committed, however, the threshold for entering the provisional measures stage is low, then it means that when states go to court, they actually aim at the provisional measures, not so much trying to win the case, but trying to create pressure using the provisional measure. And I think this is actually what we're seeing now in the South African case. I'm not sure they're too interested in the questions which will, I hope, be hypothetical by the time the court will come to a judgment on the merits regarding whether indeed Israel committed genocide. They're more interested in creating the pressure now when when the forces are on the ground.
Right, and I want to get to the substance of the issue and the accusations, but just last point on the jurisdictional thing that I want to clarify for everyone is I've heard some people saying, well, why isn't a Hamas a party here? How come this is just a complaint filed against Israel? Why isn't somebody filing a complaint against Hamas? And of course, the answer to that is that Hamas is not a state, is technically not a state actor, even though they are the reigning authority, elected government in Gaza. And I think that's very important because there is no way, in effect, to haul Hamas before the ICJ and say no. This is what happened on October 7th. Was a genocide. I've heard some people refer to it as actually a potential crime against humanity. Amichai.
Just a sentence, but you can hold Iran into the ICJ.
Yes, potentially, though then you have to establish the connection between Hamas's actions and Iran, which is not easy.
Incitement, I think it's very clear that Iran is continuously involved for the past decades in state incitement to genocide. And once they open this box, I'm not sure Israel will do it. I think once Israel is there, I can see no reason why not to bring Iran, at least in the incitement crime, which is a separate crime under the convention.
Yeah, so this issue of Hamas not being a party to this case, I think is very important because it really speaks to this issue of what the outcome of the hearing today is going to be. So just say, for the sake of argument, that South Africa, wins and convinces the court that it has jurisdiction and that something has gone wrong here. And then, well, what does the court order? What's the actual ruling? They have the authority to issue provisional measures. But the question is, what would those provisional measures say? Like, what would the order be to the parties of the armed conflict? And ideally, when you have an armed conflict, you can say to both sides, hey, stop, like a ceasefire now, stop the armed conflict. But because of this issue that you pointed out, that Hamas is not a party, they wouldn't be able to speak to both sides of the armed conflict and say, stop fighting. They would essentially just have to speak to Israel and say, stop fighting. And for many observers, that leads people to, I think, be a little bit skeptical that the court, just as a prediction, would do that, because I think people would be disturbed if the court was making that order to one side of the armed conflict. The other possibility is that they might say, we're ordering Israel to comply with its obligations under international law, under the Genocide Convention or under IHL, the laws of war, so on and so forth, which is kind of a watered down protective measure, because Israel and everyone else is already required by international law to do X, Y, and Z. And a protective measure that just says comply with international law is kind of not really adding anything to it. So it's kind of a soft.
Well, and of course, Israel maintains that it is complying with international law.
Yeah.
And we'll set about to prove that. I want what South African attorneys there are describing is extreme conditions of starvation, lack of water, disease, really terrible conditions for civilians in Gaza. Israelis have charged that Hamas takes large portions of aid, particularly gasoline, that it allows through checkpoints and that gets into Gaza. They've also recently made the case, at least to me personally, on a recent trip to Israel, that their self-defense efforts are set back by large amounts of gas that Hamas has been able to stockpile as a result of the recent decision Israel made to allow gas through the checkpoints and to start allowing it with the intention of having the gas go to run hospitals and so on. And in fact, they find that the shortages continue and that Hamas is stockpiling that gas to have energy to run their operations in underground tunnels. So this does not get a mention in the South African case. As we were talking about earlier, Amichai, there was no mention of Hamas really anywhere in the arguments. But a description of a fairly dire, terribly dire situation on the ground in Gaza. So how do we think about this in terms of the accusation of genocide? Amichai, I'll start with you.
First of all, we think about it in the way we should initially approach this entire area, and that war should be condemned, and if we can avoid war, everyone will be better. And it's clear that war creates immense suffering of civilians. There's no disagreement about this fact. And as you mentioned, the fact that Hamas does not appear, so there's no explanation of the fact that Israel thinks that bringing in fuel means that the Hamas will be able also to fuel its generators in the tunnel, and therefore continue fighting in the tunnel, because a lot of the fuel will go to the Hamas, not to the civilians, and so forth, regarding other humanitarian assistance. Without understanding this, the discussion cannot proceed regarding the laws of armed conflict. And it's clear why South Africa is avoiding this discussion. Because if this is the discussion, then it's discussion on the issues that Dean Ohlin and myself have written on, and it's actually a discussion of proportionality. Perhaps Israel is acting in a disproportional manner. I don't know. We can think about it. We can even debate it. But that's not enough. That would be outside the jurisdiction of the court. South Africa must ignore the Hamas in order to present a picture according to which Israel is deliberately acting in order to harm civilians. Otherwise, they have no case. And hence, they have to pull Hamas out of the picture. And then there is actually no explanation apart from deliberate attack on civilians for what is happening. And this brings it into the sphere of the jurisdiction of the court.
Let me get Jens in on this. Jens, what are your thoughts about the humanitarian catastrophe that is Gaza and the method of proving genocide by reference to that catastrophe?
Yeah, so I mean, clearly there is a humanitarian catastrophe going on in Gaza. A humanitarian catastrophe could, in theory, prove the predicate act of deliberately inflicting on a group conditions of life calculated to bring about its physical destruction. But to show that, you really have to demonstrate who is responsible for creating the humanitarian disaster. And in this case, the complication is, well, it could be Israel, it could be Hamas because Hamas is confiscating supplies, or it could be Egypt because Egypt also has a border with Gaza, or it could be some combination of the three actors. And you kind of have to sort of parse out in order to figure out, have you done something to deliberately inflict this? Who is responsible for it? The other thing I would say is figuring out who is responsible requires a careful attention to the timeline, because an ascription of responsibility might change at various points in time as the facts evolve. So it's possible that at one moment in time, one party might be responsible for creating this situation, but then at another point in time, not, either because relief supplies were blockaded at one point and then they were not blockaded at another point, so the situation has evolved, or this is an even more complicated issue. One's responsibilities to provide assistance might change over time, depending on whether or not someone is an occupied power. If Gaza is under a state of occupation and Israel is an occupying power, either before or now or in the future, then they have an actual positive obligation to provide relief supplies. And I suspect this issue is going to be hotly debated by the court. There's a lot of different views out there. Some people hold the view that Israel, by sort of controlling the borders around Gaza, has been an occupying power for years. I think that's
the fact of having pulled out in 2005 and turning Gaza over to Palestinian self-rule.
Exactly. And some people might say, okay, well, now they're clearly an occupied power because they're fighting in Gaza. Although even that, I think, is a complicated question, because given the amount of hostilities, meaning fighting back and forth between Hamas and Israel, they're shooting at each other. Israel does not have solidified control of Gaza now. So there's a strong argument that they're not even an occupied power now, today. But in the future, they might be. I mean, if they really solidify control over Gaza, they will then become an occupied power. And at that moment in time, when that switch is flipped, if Israel becomes the occupied power because they kill enough Hamas terrorists and Hamas is gone, and the only kind of controlling authority there is the Israeli Defense Forces, they immediately acquire a positive obligation to take care of that civilian population. And at that point, the responsibility is all on them to do something.
Right.
if I may
Quick
ask,
response, Amichai, and then we're
no,
getting
I just have a question.
Yeah.
Even assuming that Israel has responsibilities as an occupying power, and let's assume it's violating its obligations, how does this translate into genocide?
Right. And there the other piece of it is this genocidal intent argument, which I won't, in the interest of time, show a clip from here. But as you referred to earlier, Amichai, there was a discussion of the statements of Israeli officials, and then an argument on South Africa's part that, in fact, these statements characterized the conduct of Israel in war, and that there was an attempt and an intent on Israel's part to target Palestinians as such.
Yeah, two very quick points about this, because this is going to be a huge part of the case. South Africa, this is, one thing that they can really seize on, as Professor Cohen mentioned. One thing that I think is not good for South Africa is that these officials are not closely connected to the decision-making power of the government. These are kind of fringe statements from fringe people. And so that's kind of the cherry picking argument that they don't, if statements by Netanyahu or by the, Secretary of Defense, those really mean a lot, but just like some random people. On the other hand, what's bad for Israel is, how did they sufficiently disavow these statements? And I think they're now kind of rushing to be a little bit more aggressive in terms of disavowing them and saying, we disagree with these statements. These are not government things. We're even going to criminally investigate people if they engage in incitement to genocide. They probably should have done that right at the very beginning, but at least they're doing that now.
Right. So the question is what weight the court is likely to give these statements. As Jens, as you say, a number of them are not officials, but there were some somewhat damning statements by Gallant there. However, some of the difficulties that will need to be addressed is the intermixing of the civilian population with Hamas, not only because of the practice of human shielding, which is extensive, but also because of this phenomenon known as civilians participating in hostilities. And we do know that the Palestinian Authority is still paying the families of ordinary Palestinians, I don't mean members of Hamas, who kill Jews. And accept the claim and celebrate the claim that they've been martyred. So there is an intermixing there. And in fact, Jens, you've written extensively about civilians participating in hostilities and how we think about those difficulties of distinction. I wonder if you want to make any comment about that, and then let me get Amichai in.
Well, I do, because I think, who you're targeting and why you're targeting them is really, really important, or why you're killing people. So, killing a civilian is generally not allowed unless they're participating in armed conflict. Then they become, someone who's subject to attack. And even to connect it up to this larger issue that we were just talking about, genocidal intent, even if you say, we're going to kill these people or we're going to destroy them, it really, the interpretation of that statement really matters. Like, well, who are you talking about? Are you talking about your military enemy, or are you talking about the civilian population? And if there's a blending between the two, why are you picking out that person and describing them as an enemy? There's kind of an interesting analog to this in the Rwandan case, where courts really had to pick through a lot of statements that were in the Rwandan media at the time, saying we really need to destroy our enemies, and describing the enemies in really kind of graphic, disgusting terms. And the real question in terms of, is that genocide, is, well, when you say we're going to kill them, do you mean your military enemy like Hamas? Like, if you say we're going to kill Hamas is evil, Israel has a right to do that. That's not genocide. But if you're saying we want to kill them, and what you really mean is we want to kill all of them because they're Palestinians, that's not okay. And so reading between the lines is really, really important. And that's what any court is going to have to do in this circumstance, is really get to the kind of true meaning of these statements.
Right. Amichai?
I want to add just two comments. First of all, the wording of the convention is important, I think. It
Yes.
says that the intention has to be destroying the group as such, meaning that the reason you want to kill them is because they are part of this group. And this is even a higher threshold to prove. So that's one point. Second point is that, and I think that the comment here was correct. There is a separate crime of incitement to genocide. And these statements by Israeli politicians should be condemned. But what the South Africans are doing is not attempting to build a case for incitement of genocide. What they are trying to show is more complex. They are trying to show, and this is the reason they bring in the clips of soldiers. They are trying to show that actually these fringe politicians or politicians which have no actual power in decision-making circles actually affect the way the soldiers conduct in their actions in the wars. That's the real claim and the real nexus they are trying to build there. Once again, Israel should condemn this, and it has been done. And I would say, from my point of view, there is at least one positive result from this case, and it's that indeed internal Israeli mechanisms have begun, and it shouldn't have been done only under international pressure, but now it's being done, condemning these. And I think today in the Israeli media there was one consensus, and it's that these people have put Israel in trouble and they should be condemned for it. And I think, but this, once again, the claim made is trying to translate this into an entire Israeli plan of committing genocide. And
yeah, so
I think it doesn't prove it.
Get to some of the questions. Some of the questions we've already addressed along the way, but I'm gonna pick those that have not been addressed. So an interesting question from Mark Feldman. Doesn't the fact that the Palestinians elected Hamas to run their government make them responsible too for the violence against Israel? And let me elaborate that question by saying, is there a case to be made that Hamas is actually a state actor? Well, we touched on this briefly in talking about what is the status of Gaza. Is it an occupied territory, or is it an independent principality in effect? But if it's an independent territory, then do Hamas members of Hamas not have state actors? Should they not have state actor status? Jens, do you have a thought on that?
There is it's not a trivial argument. It's a plausible argument. It's a little bit complicated by the fact that we were on a clear sort of path to recognizing Palestinian sovereignty and statehood before the split between the Palestinian Authority and Hamas. And now the Palestinian state is bifurcated, and so you to fit the facts, you'd really have to say, well, there's really two states here. There's the Palestinian Authority in the West Bank, which is one state, and then there's Gaza, Palestine as a separate state, because Hamas's authority only extends so far as Gaza. You can probably make that argument, but the thing is that international recognition was about Palestine as a whole and not really about like a separate kind of sub-state entity called Gaza. But you could go in that direction, but I'm not sure what hinges on that, by the way. Even if Hamas is a state actor and Palestine is responsible for it, that doesn't really change Israel's obligations under the Genocide Convention. And I'm not sure it changes that. I mean, it would transform this into an international armed conflict, and a few legal things change, but obligations under the Genocide Convention, I'm doubtful.
And of course, Hamas is not a signatory to as such, is not a signatory to the Genocide Convention, so they would not submit to the jurisdiction of the court. Another question from Jill Posner. Do we feel the ICJ is impartial? Certainly the UN has a demonstrated anti-Israel bias. Amichai, do you want to take that one?
So, as was mentioned in the beginning of our session, which was already a while ago, so maybe people don't remember exactly. So there are 15 permanent justices on the court, and they are elected by the General Assembly according to a geographical distribution. Some of them come from countries like China and Russia and Somalia, which are not known for judicial independence. But a majority, I think, of justices, perhaps not a large majority, but a majority of justices do come from countries that respect and value judicial independence. So the US, France, Germany, Japan, Slovakia, Brazil, Jamaica, etc. So the question, I think, is whether the justices from these countries will decide according to the law, international law. And I think that appointing Justice Aaron Barak to the court as an ad hoc justice, more than the question of his personal contribution towards understanding of international law, is also an attempt to signal to these judges, because Barak was attacked this past year by the Israeli government. He was demonized as the architect of the Israeli constitutional revolution, which the judicial overhaul in Israel tried to overturn. And then, so this judge signifies an independent judge who the government doesn't like. And when he was appointed, it's actually, I think, an attempt to signal to the judges in the court who come from democracies of their obligation to follow the law and not necessarily the interest of the parties. Hence, I have some faith, at least hope, that the result will be based on the law.
I'd like to just
international.
Very briefly squeeze in two more excellent questions that are in our queue at lightning speed, and then we're going to end. From Ramu Jallo, who is, for those of you who don't know, is our fellow here at Searle this year. She asks, it seems that more and more countries are submitting applications for provisional measures before the ICJ under the Genocide Convention, Gambia, Ukraine. How useful will the jurisprudence from these cases be in deterring future cases of genocide? Do they have real substantive value? We sort of touched on this briefly, but Jens, do you want to take that up?
Yeah, I think they have huge value because I think the jurisprudence on genocide is had been a little bit thin before. As Professor Cohen mentioned, there's Bosnia versus Serbia, a prior world court case, and then there's a lot of criminal cases. But in terms of state responsibility, there hasn't been as much law. So I guess one silver lining from all of these cases is you're going to get a rich jurisprudence, and I think there's going to be a progressive development of the law. There's a little bit of a risk, that the court's docket could explode, and we've already discussed that as a potential risk. But there's no question that Ukraine versus Russia is going to be a very important precedent. The case between the Gambia and Myanmar is going to be a relevant precedent that the court's going to have to, is going to rely on. And then even that Bosnia-Serbia case, talking about control and, when does an external state have authority enough over control over a non-state actor that they take responsibility for their behavior. That's also going to be relevant. So it's interesting stuff.
And a last very quick question, which is it possible for the court to issue a conditional order, like an injunction conditioned on, say, release of the hostages? Right? So could the court fashion a provisional measure saying Israel has to stop its offensive, but that is conditional upon release of the hostages, so that measure would not kick in until all the hostages were returned.
I'm very curious what Professor Cohen thinks about this. I mean, I'm doubtful that they would do that. They could, I think, say both sides have to. I mean, I said before that they can't legally speak to Hamas as a non-state actor, although, there's a difference between what they say at the bottom in terms of what the official kind of outcome is and then what they put in the paragraphs. They can say anything they want in the paragraphs and it would sort of be dicta. They could say, the hostages must be released and Israel needs to stop, fighting Hamas. They could, in theory, say that, I suppose, but I'm doubtful that they would. But I'm curious about Professor Cohen's view.
I'm trying to find, a comparable case. That what happened in Ukraine versus Russia case is that the Ukrainians declared before the court that if Russia would stop, they would also stop. So there was a clear declaration, of course, and then the court was able, I think, to decide. It's I'll have to I'll have to think about it and I'll respond. And if you'll give me the name of the person who asked, I'll even respond directly because this is a very interesting question and which I'm not sure I have an answer of my sleeve to.
We are over time. Thank you so much to our guests, Amichai Cohen and Jens Ohlin. I can't thank you enough for joining us. We will see what Israel's arguments tomorrow morning bring. For those of you who are up at 4 a.m., you can hear it live, or you can hear it a few hours later on the internet. And we'll be discussing that next week, though our focus will likely be different, but we will certainly touch on that. So thank you. We'll be continuing our weekly briefings for the foreseeable future. Additional topics that we'll be addressing will be sexual violence in war, lawfare, disinformation, and all aspects of the conflict. We very much appreciate your suggestions, so please feel free to write us at Searle and give us your ideas for topics that you'd like us to cover that are relevant to the Israel-Hamas conflict. Thank you so much for joining us.
All right, everybody. Thank you for joining us, and please stay tuned for next week's edition. We'll push that out on our mailing list, and the video of this event today will be up in short order on Searle's YouTube channel. And thank you very much, and have a pleasant afternoon.